person. An accused person under Article 50.
Yes, Mr.
Under Article 50 of the Constitution, an accused person has a right to be informed in sufficient detail of the charges proposed against him. Sufficient detail. What is presented as a charge sheet if you look at the count 1, it talks of cyber harassment. But look at the particulars. That is where the devil lies. And where the devil lies, it sets out a purported ex post, but proceeds to show you where he's sleeping. Content whose information you knew to be false and calculated to tarnish and discredit the reputation of one David Lagat. This speaks, Your Honor, to a question of reputation, not harassment. And if it is reputation, it's defamation. If David Lagat or William Ruto thinks that this post has injured their reputation in the eyes of right-thinking members of the society, their recourse is in the civil court. They sue for defamation. And criminal defamation is no longer applicable in our legal system. But if the particulars presented before Your Honor yes.
We don't know that they are going to be reporting this one with blood pressure. So you need just to check on your voice so that
And become like tomato. I know sometimes I sting like a pig. The bottom of my own. I not eject. So, Your Honor, that's all I do. The particulars disclosed in the charge sheet speak to defamation, which is a civil wrong. The count in the charge sheet speaks to cyber harassment. There's dissonance in the two. So will Mr. Morara be required to respond to the count of cyber harassment or the particulars of defamation? That charge sheet, Your Honor, should not be registered at this particular point. And the state can advise the complainant that in relation to reputation, the Chief Magistrate's Court Milimani exists, civil division. You can go there. In relation to cyber harassment, the complainant should come with better particulars, not these ones. So having dissected those two, the particulars of the charge and the count on the charge sheet, Your Honor should exercise your discretion and refuse to register this charge as presented before you, and direct that Mr. Morara to this set free forthwith,
unless otherwise lawfully detained. So this is prejudicial at the outset. That's all.
Very, very kind condition. Just a moment. If I write everything, if I say the one day,
That's what justice is about.
that's the challenge, that's why.
We respond to what we don't know. We don't know what our people want to say. So I'll be working manually because we have not set up the gadgets. We didn't know this case of this kind coming today. So now just for your information, because now the gadgets have been set up, I will now not be writing. But please, when you speak, say your name at the beginning and use a microphone. So we have them transcripted.
Try Pure Active, the #1 anti-pimple cleanser with salicylic acid and charcoal to reduce pimple-causing germs.
And to the process forward. You know, I'll pick it up from where my learned senior Mr. Otieno left it, and urges to go straight to Article 25 of the Constitution on rights that cannot be limited, Your Honor. One of the rights that cannot be limited, and while all other rights can be limited, is the right to fair. C of the Constitution. I'll, with humility, invite the court to read that together with the provisions of Article 52B. Which my learned senior, where my learned senior left. 52B, Your Honor, is about the right of the accused person to be Your Honor, 52A, all what constitutes trial. Such that, Your Honor, as we stand before you this morning or afternoon,
the charge that has been read out. That's all from you.
I leave the floor to my team.
Yes, Your Honor, I just wanted to say one or two things. Yes, Your Honor, my name is Eric Ulrich. Your Honor, you've been referred to articles to refresh what has been stated. But Your Honor, so that you are not told that this court cannot deal with the questions of constitutional interpretation, Then I also wish to refer this court to the Criminal Procedure Code, and I would want to make reference to sections 135 with regard to the framing of charges. Section 135 with regards to the framing of charges. And Your Honor, it underpins the constitutional requirements that an accused person is entitled to sufficient information to be in a position to respond to the charges that are made against that person. Your Honor, second, you have the jurisdiction and the discretion under section 89 of the CPC to decline these charges if you are of the opinion, and Your Honor, we persuade you to be of this opinion, that the charge sheet before you does not, in sufficient material, disclose a case to enable the accused person to take a plea. Your Honor, I'll finally say it, and I think I have said this before. If we continue at this rate, we will have to seriously expand this form. Because, Your Honor, what it would mean is that any statement that a person can make under the free speech that is guaranteed in this country. Sometimes, yes, I can say something that can be offensive, but does that constitute a crime? It's the danger that we face with this kind of charges. Your Honor, for those reasons, and being that these courts are temples of justice, there are games that can be played. And Your Honor, I think it is also important for me to say that this court has recognized, and the High Court, I think, has recognized the manner in which of late police have been conducting their arrests by way of abduction of those people they consider to be suspect. There is actually an order of the High Court that has directed that the police must comply with the law when it comes to effecting arrest. So when someone is abducted, like the accused was abducted, in clear contravention of a court order, and then he's brought here for the court to sanctify the actions, the illegal actions that have been undertaken. And the attempt to sanctify, Your Honor, those actions does not meet what is contained in our laws in terms of the kind of charges that should be presented and accepted before the court. Your Honor, this court must remain what it is supposed to be, a court of law. We may not be able to stop the police in the manner in which they are behaving, but there must be a place where they know that they can play their little games outside there with the lives of each and every one of us, because it basically means that no one is safe. I can make a statement that it is deemed criminal. Let them know that those games will not be entertained within the corridors of justice. And so, Your Honor, I plead with this court that we must take all the circumstances of this case, and the circumstances of this case then explain the paucity in the charge sheet as has been presented before.
Your Honor, I think there was magic yes, and it's more than the court directing to this
We call for a short adjournment so that the court is clear and the person has care. They need a short adjournment.
There are some other rooms on the other side that are bigger and more. No, this is the biggest. Wampeleke the other
Thank you, Your Honor. It is the last time we appeared in the court over this matter. The court had to buy me microphone. I was avoiding that because I don't want it to go on record. But it looks like, I mean, at a certain point, we may really need to think about fasting and whatever, the manner that we are. But Your Honor, what I was saying is that the circumstances of the arrest and then demonstrate why. Yes, Your Honor. Yes, Your Honor. So my final point was that even though it might appear to be an overreach, but this court must look at the circumstances of the arrest, and it will be able to understand that the intention here is for this court to be a convert. We abducted him, we were unable to. So, Your Honor, what I was saying is that this court is then intended to be an umbrella. We abduct or we arrest without any probable cause. We look for any reason and we present a charge sheet and place it before the court. And the court then is supposed to be the one to sanctify, because Your Honor, the moment you accept this charge, and I think if it was a proper charge, we would have no problem, even though we would have known it is fictitious. But the problem here is that, Your Honor, if you accept this charge sheet, especially as it is fair, and then even this court will eventually almost be on trial the way our police are on trial. You know, for that reason, I'm noting that Mr. Morara had a young counsel that he had instructed. I'll ask that you allow Mr. Semonka to just say one more thing, and then I know all of us would want to say something. But I also need to write ruling and listen. I'm being reminded it's also a
Please, Your Honor, my name is Marem. I humbly and wholly appreciate the recognition of my land seniors, and I thank them for the knowledge that I received in the country. However, there's one small thing that we haven't touched. And briefly, that's to do with the framing of charges under Section 134 of the CPC, as read together with Section 135 of the Criminal Procedure Code, which dictates in mandatory terms that a charge must contain a statement of the specific offense in which the accused is charged, and enough information to demonstrate the nature of the offense. Much has been said about civil defamation. However, in brief, Your Honor, if you see count, it refers to cyber harassment under Section 27 of the Computer and Mission and Cyber Crime Act. However, when you read the particulars of the offense, specifically line 4, knowingly without lawful cause, knowingly without lawful excuse, posted false information. That is another offense under the Computer Mission and Cyber Crime Act. Specifically Section 22 of the Computer and Cyber Crime Act. If you go on further on, they repeated the statement, false, again. And then lastly finished with calculated to tarnish and calculated to tarnish and discredit the reputation of one David Morara. So, Your Honor, in brief, the question is Morara answering to the charge of cyber harassment or to the charge of publishing false information or to civil or defamation? Your Honor, in brief, as I associated both my learned senior counsel Eric Theory stated, I was with Morara when he was being arrested. The police refused to grant me access. The Article 49, and there are orders that have been given by the High Court that the police ought to respect and ought to follow Article 49 of the Constitution. Some of those orders I personally obtained them from the High Court. Additionally, they did not disclose why they were arresting him or who they were. Some of them were masked. Your Honor, the question is, we are dealing with people.
Sorry. All of us end up painting here. So please, just a request that you allow me to manage the crowd. I want to request everybody after the gentleman with the big camera. We are just going to ask you kindly to step out of the room. Otherwise, we can't face the Please, you can listen from outside. We have speakers, so you'll be able to now, if you have problems with that, we just have to wait. Because health comes first. Please. But I want to see you country speaking.
Oh yes, Your Honor. So,
Because you can get, so many of us are sweating. You can get the smell of sweat. That is really long.
yes, Your Honor, I'll be brief. Your Honor,
How many more minutes do you take?
3-4 minutes.
Okay, please.
Your Honor, in brief, what we are witnessing here as a country is the weaponization of the criminal judicial process against a young man who, against all odds, stood up to speak the truth. And the truth has hurt many people who are currently in power. That truth has altered the status quo.
Sorry, you are not a witness. You are yet to take lead.
But in brief, Your Honor, history is being made, and I invite this honorable court to stand on the right side of history by quashing these charges and releasing the accused person on personal bond. He is a young person, he is a young patriot. To release, to free him completely, discharge him. And lastly, as his personal lawyer, I want to thank him for actually believing in a young person. Fellow Gen Z, Your Honor. Fellow Gen Z. And we will stand with him together.
May the court afford exactly 1.5 minutes. My name is Chair Bradley. It's a privilege to appear before you, Your Honor, in this matter. And just to add to what has been said, the constitutional justification for the cause of action we are requesting you to take. If you look at Article 24, it is a balancing act that the court must strike. And the court must look at the least restrictive alternative. In this case, Your Honor, there is an alternative for the complainants. That alternative is called the Defamation Act. It's sufficient to address any reputational damages. And so there will be justice for the complainant, whichever, if you make the decision we are requesting you to make. And the other one is in Article 23A. That article obligates this court to adopt Article 20 Sabbatical 3A. You know, this court cannot interpret the Constitution. That jurisdiction belongs to the High Court. However, this court, as a constitutional organ, must apply the Constitution. And when you look at Article 23A, it requires this court and all tribunals to adopt the interpretation that most favors the enjoyment of rights. In this case, Morara's right to freedom of speech. especially on these issues, is about. So, Your Honor, there's sufficient legal basis for you to find that this charge does not disclose a criminal case, and that the remedy or alternative remedy of defamation is sufficient. Thank you so much.
Your Honor, perhaps before the prosecution responds.
Just a minute, Mr. Mayor.
Only one about the charge sheet, because it will become relevant for them in response. Only one. Perhaps, Your Honor, to just disclose the bad faith in which this matter has been instituted. That the charge sheet itself is indicating erroneous dates when our client was arrested. They say that they arrested him today. The fact is that they arrested him yesterday. They have a duty to disclose all the material facts, and there is a reason why the CPC requires a date of arrest to be indicated on a charge sheet. Eventually, Your Honor, when you seek to retire, kindly order the DCI office, and this is the DCI himself, to release 3 phones and 1 laptop belonging to our client forthwith, as it is charged him. Most obliged.
Even though we just have a brief response, maybe to just start off, it's the first time I'm seeing Mr. Ndegwanji very calm. So it is unlike him. Your Honor, just in brief response, in terms of arrest, it's true the accused person was arrested yesterday and has been produced in court within the required time limit.
Your name for the record?
Undimu. And has been produced in court within the required time limit. In terms of access to counsel, I did confirm with the officers that he was allowed access to counsel, and the counsel who was allowed was Mr. Ndegwanji. And in fact, Mr. Ndegwanji did appear at our office today morning. And we confirmed that the charge sheet will be brought. He was accompanied by 2 other counsels, though they declined my tea invitation. Your Honor, in terms of the charge sheet, the CPC is very clear
that a charge sheet must contain 2 critical elements.
He was accompanied by 2 other counsels, though they declined my tea invitation. Your Honor, my colleagues, my senior colleagues and junior colleagues have not disputed that there is a statement of the offense and the particulars. The contention, especially my senior colleagues have raised, is What is harassment? Your Honor, I look at that particular act, the Computer Nuisance and Cyber Crimes Act. It does not in any way define what harassment is. Harassment takes various forms. One, to draw a conclusion that harassment has occurred. The particulars in the charge have clearly informed the accused person of the accusation that he is facing. And what my colleagues are asking you to do is to go to the substance and the merits of the charges, to go to the evidential material. As at this point, Your Honor,
Just one.
as at this point, what court ought to consider that the particulars of the charge have sufficiently informed the accused person of the accusation against him, which in our humble view are sufficient to enable him respond to the charges. To delve into other issues, Your Honor, would be going to the merits and demerits of the particular matter. I do understand the constitutional issue that have been raised by my senior colleagues. And those issues cannot be raised as at this point. The only purpose we are here for today is purposes of the charge sheet, whether it has statement of the offense and the particulars of the offense and other considerations. Refer this court to section 137 of the CPC. Your Honor, on the last point that Mr. Ndegwa has raised, on the issue of the 3 phones and 1 laptop, I undertake to follow up the issue with the investigating officer to find out if they are interested in the material or the same should be released to the accused person. I undertake to inform him before the closure of business today as to what the response of the investigating officer has been. Luckily, I have Mr. Ndegwa's number. And also Mr. Eric Theuri. Surprisingly, the squatter from Tuapa has not spoken. I'm sure he will respond.
My colleague from the DPP, let the record reflect that my name is Morara, Law Society of Kenya Vice President. Vice President. I put a rejoinder at the end. Thank you so much.
We only respond to the issue of the charge sheet. The other issue are more constrained, as at this point this court only ought to consider whether the statement of the offense meets the legal criteria and whether the particulars of the offense have contained sufficient details. And I've gone to the issue of the harassment. I think yes.
Martha Karua, SC, leading the defense team. Just to remind the court that our plea is that the charge be dismissed or rejected as defective under 89.5 of the CPC. Our submissions by the various councils point to that direction in adequate words. And it is important that the court only invites the accused to plead to a charge that discloses a course of action. And we have shown the mismatch between the offense charged and the particulars. I need not go beyond that. But when you retire to make a ruling, should you require more time, we urge you to consider releasing Mr. Morara, who is, I'm informed, is an officer of this court, on a personal board. He is, I'm informed he's not an officer of the court, but he is a person who is well known, has a fixed abode in town, and he is not a flight risk. You may consider releasing him on a personal bond, because we must not encourage the behavior of the police of punishing people in advance of appearing before the court. By punishing, I mean detention, unnecessary detention. He is a person who can actually be released on freedom, and we are many, and we will make sure he appears.
I think that should bring it to a close. So you want to bring in this part?
That will be the best approach, but you understand that you may have to read and do some research. And it may not be possible. That is why my learned senior counsel member asked that if that be the case, we can ask Mr. Morara to be admitted to free bond, and as his counsels we
So
undertake.
Mr. Tieno, now you're out of it. The environment is not conducive. I think I should release the exam.
Yes.
The best way to do that is to preserve the ruling.
We still come tomorrow.
Senior counsel, what does your plan to do? Or what terms would you consider appropriate?
He is a businessman, and he is a very well-known, active, and engaged citizen.
That's fine.
And he's also a lawyer waiting to be admitted. I actually thought he was already admitted. That's why I'm saying officer of the court.
So he can afford cash bail of 1 million.
Yeah.
Bond of 1 million. That's in order. Otherwise,
How much cash bail is he able to
free bond of 1
Maybe Maybe Your Honor, just before you pen off, my colleagues have made submissions on the issue of bail. I just wanted to go on record that we are not objecting to bail. Maybe on condition that my Vice President ensures that he reports to the investigating officer whenever he is required.
So today, first, what has to speak tomorrow, you come on 3rd of October. Sorry, no, 3rd of October. You come tomorrow at 2 p.m. tomorrow. Yes.
Is that Thursday?
Tomorrow is Wednesday.
Oh, okay. The court, Your Honor is proposing Thursday, the 3rd, or tomorrow, the 2nd?
Morning.
Sorry, the 3rd of October.
Would we go to 4? Would we go to 4 that will give you enough time? In the morning.
See, I'm already confused. So, ruling on the application to be delivered on 4th of October this year at 2 p.m. Morning. I know what I'm saying too. I have a very long hearing at the moment. And the accused person is granted cash bail of Kenya shillings 50,000 with one that person to appear before the court on 4th of October this year. Why not?
Contact just comes
May I just take this opportunity on behalf of all the advocates to thank the court for the indulgence. Of course, I must recognize that my good friend, Mr. Ndimu, although he's linked into town and has not yet performed the usual rituals for us to welcome him into the room, has behaved as graciously as he always has. We understand that they are operating under very difficult circumstances. But Your Honor, we want to just say thank you for the indulgence and we'll see you on Thursday.
Thank you. We are still here, so if you feel like moving out, please do so peacefully.
Number 1021 of 2024, Ferdinand. Give them some time. Please try to be silent. Is he in custody or out on bond?
we had seen him in the morning along with Morara, so we know he is around.
Mr. Ondimo,
Yes, he's
we don't have time really.
Kwake sasa
Ongea, unasikika?
Ndio tumetoka kotini kukaa na president wetu 2027 na tumemaliza kesi, imetupiliwa mbali sababu hiyo charge sheet ilikuwa ya ufala.
The bail right now, and Morara is going to be out. Then we will be back here on Thursday at 2 p.m. So stay put, be there for any support that is needed. Let us work together to ensure that we fight impunity to the very end. Thank you, and we love you guys.
Thank you, Secretary. Kenya, whenever you're given a charge sheet, look twice. Only one thing that I highlighted, the date was wrong. They arrested him the day before today, and they are requesting the court to give them some time to go and write. We forgot we arrested him yesterday, so today was a wrong date indication, of which it was done by Mr. Amin himself. So the case has been thrown out. Hata hiyo 50,000 ya maji tu. Tumeona mkubwa amekaa hapo sana. Isikuwe tu madharau, lakini it has been thrown out. So he will be here now. Is the one we are waiting for. Okay?
But also for the comrades who have come to stand in solidarity with the Morara Kebaso. We are for you. We stand with you. Viva! We stand for Morara because he is our choice. He speaks on behalf of many people
and
in this country, Kenya.
We are going to sue this court.
Yes.
Because it has not observed the hygiene. There is the disposal of waste waste matter, water, soapy water, and plastics within the corridors of the courts.
Even toilets.
Broken windows everywhere, endangering our lives, the lives of the lawyers and the judges. So we are going to sue this court as well because of not observing environmental hygiene.
So let the guys remain vigilant. Remain vigilant. It is not over until it is over. We are on a mission. We are on a mission. 2027 ama kesho kutwa. Biashara viva vijana viva. That's what we stand for.
Nataka kushukuru majenzi na milio na Wakenya wote kwa kusimama imara.
Najua unajali kizazi chako cha kesho. Kitu inapenia watoto wetu saa hii guys. Kitu inapenia mabwana zetu saa hii. Wanawake wote msimame. Wanawake wote wenye mmejitokeza, mimi nawapatia mkono. Wanawake wote msimame. Tuendelee kushikana kama ile kitu. Tushikane wote tutoke. Watoto wetu are not safe guys. Bruce is our brother. They are not safe. Morara is our brother. Morara is someone's husband. Ni baba ya mtu. Wanawake wote endeleeni kujitokeza. Mimi nitakuwa najitokeza, wanawake tushikane, tutoke nje tukuje kwa barabara. Tutetee haki zetu, tutetee watoto wetu, kwa mambo yote yenye yanafanyika guys. Thank you very much na mbarikiwe.
Asante sana. Ninaposimama hapa naongea kwa ajili ya Morara, nasema huyo ndio anatosha na anatosha kuwa rais wa Kenya, anatosha kukalia hiyo kiti. Hata saa hii huyo rais aende mafichoni mahali anataka kupeleka watu. Wanaopeleka watu hawana hatia. Jameni, mnachukuliwa, mnapangiwa njama. Hii serikali si serikali, ni kikosi ya kutengeneza pesa. Jueni kuna Mungu, tafuteni Mungu, achaneni na pesa. Mnachukuliwa mtu kama njoo, mnaandamana siku mbili, mnachukuliwa njoo, hakona utajiri, anaweza simama pale Likoni apeane pesa kutoka asubuhi mpaka jioni. Hiyo pesa yake itaisha, na ndipo unaona unashikwa Mombasa hati na ningaba na anakushika wewe, unashikwa ni watu hati unafunguliwa mbuti, unaangaliwa nyuma na wewe ni mwanaume, na ni wanaume wenzako wanakuangalia nyuma.
Sky High Mascara, now boarding, limitless length and volume. Maybelline, New York.
Aliwa nyuma na wewe ni mwanaume,